All right. I am going to reintroduce Judy Bernstein-Baker, Executive Director of HIAS Pennsylvania. She's going to make a brief announcement. Some of you were here for the morning. This may be a repeat. I apologize in advance. To those who are new, here is Judy Bernstein-Baker.
And Valentine Brown.
Oh, I'm so sorry. Valentine Brown.
This is really for, how many of you are immigration lawyers and members of AILA? This is really, no offense to anybody else, but this is really focused to you. This is like fundraising, you know, when you give a donation and you turn out, what happens? They ask you for more money, that's what happens. So you're here because you want to do pro bono, and Philadelphia is a great town for this, and we're going to ask you for another kind of pro bono. Because in addition to the children being detained, we have whole families being detained, mostly single moms with little kids, including infants, at the Burke's Family Shelter. And because of recent changes in policy, these families are facing very quick deportation, and there's a lot of problems with access to counsel in the shelter. So we were approached, AILA, I'm wearing my AILA hat now, American Immigration Lawyers Association. Valentine and I are co-chairs of the Pro Bono Committee to set up some help by the Pennsylvania Immigration Resource Center to provide access to counsel for people in the detention facilities. So, dear AILA members, you'll get this by email, but we're giving you a hard copy today. If you can come October 10th to help screen cases, not to take a case, we need you. And if you can come October 10th, you have to let us know by October 3rd because we have to send your information to the detention facility, so they'll let you in. So AILA members, think about it. This could be a one-off, but there's opportunities to do other things as well. And Valentine, did you want to add anything?
Yeah, I mean, this is going to be an ongoing opportunity. So even if you can't make it on the 10th, if you have any interest in helping, please fill out the form and we'll get you on the list. That facility is going to be expanding. There's already more families coming in, and as Judy mentioned, the hearings are going quicker. So even if you can't make it next week, please sign up and we'll provide your information to Kirk, who is doing a lot of the coordination for the pro bono services at the center.
It's only 45 minutes. Well, 50 minutes.
Yeah.
If you don't have a copy of this, we'll get you one. So raise your hand.
Before Liz is going to introduce everything, hi, I'm Stephanie. I'm going to pass around a sign-up sheet. This isn't getting you to sign up for yet more pro bono. It's more like a survey. If anyone in here has gotten a family court order for an SIJ case, can you fill this out, put your name down, circle what counties you're in, if you did as a dependency or a DR case or how you did it, just for informational purposes. I'm going to send one this way, and one down here. So if you could fill that out, that'd be helpful. Liz.
Okay, and so just real quick, show of hands, who was here this afternoon who was not here this morning? Anybody? Okay, so there's a few. So just to kind of regroup really quick, we're here today talking about special immigrant juvenile status, which is a particular legal remedy for certain unaccompanied children who are facing potential removal from the United States. And we're going to talk this afternoon about the family court aspect of these cases, which is one very crucial piece to these cases. So with us today, we have three expert panelists who have handled these cases in family court in different courts and different counties over the past couple of years, I guess. So first, Stephanie Gonzalez, private attorney with Werner Claw. Previous to that, worked with PLA, right? Mm-hmm. For a long time.
Yeah, it was 17 years in legal services.
Legal services, now doing private family law. Kara Fink, who is a professor at Penn and runs their interdisciplinary child advocacy clinic. And John Winnicott, who is both in private practice out in Chester County and is an attorney with an agency called La Comunidad Hispana, providing some legal services to the Hispanic community out there. Right. So take it away, Kara.
Okay, so I get to start. Thank you, Liz. So we're going to start. I stand because I teach, and getting in court. And if you can't hear me in the back, let me know as well. So we're going to come back to why we're even talking about family court, right? And the reason we're talking about family court, and we'll go to the next slide. Great, there we go. The reason we're talking about family court today, and that we're going to use as sort of the catch-all term for both the dependency court where children are adjudicated to be abused, neglected, or abandoned, and also domestic relations court, which handles all of the custody and guardianship matters. We're talking about that as a catch-all because in order to get your client's special immigrant juvenile status, you have to first go through one of those courts. And the reason you have to do that is because you require a special finding order attached to your SIJ application that finds that, the language up there, the child has either been abandoned, abused, or neglected by a parent, and I hope you notice the thing there that it can be one parent. It does not have to be both parents, so we often are in the process of doing single parent SIJs. Oftentimes, the parent that is coming in seeking custody is the other parent who resides here in the country. And that reunification with that parent is not viable due to the abandonment, abuse, or neglect. So those are, if we go to the next slide, those are the magic language order. We talk about that. Unless you have that, you're not going to be able to get your SIJ application through. And so when we talk about going to family court, that's the focus of this proceeding, and that's the predicate order or the special findings order that is consistently referenced. One of the things that you'll have to understand initially is where to file, and I'll turn to John in a minute to discuss that. But if you look at the language that's up there, this is not the general inquiry oftentimes for family courts, right? Family courts, and particularly domestic relations courts, are not charged with determining whether it's in the best interest for a child to go to their country of origin. They're in the business of determining whether it's in the best interest for a child to remain with their parent, whether there was abuse, neglect, or abandonment, and making findings and orders of services as a result. So for many of these courts, particularly the ones in counties where this hasn't been a practice for very long, this can be very new and unusual and unique. So part of the training and part of the purpose of having all of you sort of spread out into different counties is to start to get the courts more used to this. As you can see, the magic language focuses specifically on the parents, the issues and acts that have given rise to this young person being in the country, and for that you're going to look at whether the child has been abandoned, neglected, or abused, and we'll talk in more detail about what would rise to the statutory level for that under the Juvenile Court Act. And then we have to talk not only about the fact that reunifying with the parent is not viable, right, and that needs to be directly linked and tied to the cause for abuse, neglect, or abandonment, but you also have to provide evidence to the court of why it's not in the child's best interest to return to his or her home country. This is necessarily speculative, this is necessarily prospective, but you need to give the court some guidance about why it is important for them to stay here. Because under the SIJ Act, what you're going to have to get the family court or domestic relations court to put in that order is that it is absolutely not in the child's best interest to return. The other key factor that we'll talk about as one of the special issues towards the end is that the county has to retain jurisdiction. Again, family courts in particular, and I defer to my colleagues about the domestic relations practice, but family and dependency courts like to hold on to these cases. My cases in family court generally pend for anywhere from 1 to 3 to 10 years, depending on how old the child is. They retain jurisdiction, and these cases come back for review hearings every 90 days. So oftentimes for the family court, this is not something that they're not used to, and they're willing to do this. But again, I'll defer to you guys whether that's been an issue in the domestic relations court.
It's not uniformly in dependency court either. I think
Philly.
in Philly. Yeah, I think it does depend on the judge you get. I did an SIJ dependency, and I got it completely resolved in 2 months.
Yeah, in Chester County, they don't really want to see you again.
That's good. But here's the thing, Bucks County, because I do it in Bucks County through dependency court, if there's a placement with if the child's dependent and placed with a third party, they bring us back every 6 months for a judicial review because the court rules require that. But as far as family court's concerned, the court is not going to say they're going to retain jurisdiction over this matter because the filing can always change depending on where the child is located. And I know that language is not going to be approved by the Bucks County judge.
So what we've been able to do in Philadelphia, and they will call you back in Philadelphia every 90 days because they're going to have your SIJ case, which they'll refer to just as the immigration case when you get to court. That's right. That's going to mirror the foster care cases that are coming back in for permanency reviews every 90 days. So they will approve that language of the court retaining jurisdiction. Obviously, you're going to have to get creative if you know you're not going to get that specific magic language of arguing about why this could be conceivably consider to still be open. Okay, next slide. Oh, Kathy.
Kara, I'm sorry for the interruption. I just want to interject. Does everybody know what the difference is between dependency court and family court?
No.
What was
Okay, I saw some confusion. So dependency is abuse and neglect court. It's where the state gets involved because of allegations about abuse and neglect. Custody is generally between private parties. Mom versus dad, mom versus Aunt Sally, mom versus grandma. Okay? Everybody got it? In Philadelphia, the dependency court is at 1801 Vine Street. The family court has just moved and is located at...
Not quite moved. At the moment, it's at 34 South 11th, but there's a lovely new building on 15th and Arch, which they should be in there. Both courts are going to be in there probably by the end of the year. Family court by November, they say.
Okay, good. Clear? Yes? Okay.
It's DHS in Philly, by the way, it's the state agency, but it's CYS in the other counties.
CYF, Children, Youth, and Families, and in Chester County, Children, Youth, and Families, I don't know about in Philadelphia, but in Chester County, Children, Youth, and Families will not usually get involved in these cases. They want to know about them. You have to serve them, and their attorney will appear at every hearing. But unless you ask for services, which we have not done, their services for the child in the county, then they will not get involved. They will not petition for the child. You have to file a private petition to get into dependency court because now you're a private party. And normally, the way it normally works, what you normally think of with dependency court is a caseworker from, what is it called here?
DHS.
DHS.
Is
Little DHS.
is petitioning because there's abuse or neglect or abandonment, which are the same things you're alleging in these cases. But here we have no caseworker. So the attorney, which will be hopefully one of you, is actually filing a request first because the statute requires that you request permission because you're not a government agency, that you request permission to file a private dependency petition, which then, so there's two stages. There's a master, you're filing in front of a master to asking him for permission to actually file the petition and allow you to go in front of a common pleas dependency judge. So it's two stages.
So that's in Philadelphia County, they've sort of made that a little more efficient in that you simply file that specific request to be able to file the private petition, which is the way that we process those cases if you're coming into dependency court, not into domestic relations court, and you get approval by the chief judge, and then you are allowed to pick a couple of dates.
The Philadelphia form is in your packet.
Yep.
And we should probably, this is Barbara Kirk and Judy Martiak, who practice a lot in Bucks County. They're not on the panel, but I don't think any of us, even though I live in Bucks County, I haven't done a Bucks County case, so I've talked to them ahead of time to chime in. Because I think what you're hearing is different in every county.
It is.
I mean, immigration, I don't want to speak for immigration practitioners, but you have your regulations, that CFR business. And of course, in family court, we have the rules of civil procedure, which I call the mystery book. But how those might be applied from county to county and all the local rules is not the same. So if you're going to take from this training of family law in one particular county, you need to hook up with someone who's done it in that county. Barbara had a comment, and then Judy has a question.
And just to show the difference, if you're filing dependency in Bucks County, you have to file the application for permission to file that petition and get the judge to schedule it for a hearing just on the application.
That's same in Chester County.
And
The judge doesn't schedule the hearing.
We don't have masters in dependency court.
Okay, we
So
have.
Sam, say it's very, you're hearing, it's very different.
Very different.
In your materials that were emailed yesterday is now I'm very proud to say Philly is very streamlined. We have a form, and you can just fax in this little form. But this, for example, won't work in Chester County and won't work in Bucks. We don't know, in Delaware it won't. But the reason it's included in your materials is because it gives you the idea that there's a preliminary step, whether you can file a form or you have to file a special petition. Okay, so that should trigger your thinking. Judy?
Yeah. My question to the panelists and anybody else who's done this is strategically, what court do you go to if you could do either one? Let's say somebody's in the custody of a
My
private
county, in Chester County, it's go to dependency court. If if there's any way to avoid family court, avoid it, because it may not work. It will probably get dismissed if you file it as a custody case and it will be tricky if you file it as an orphans court and try to get guardianship. But if you go to dependency court, they're used to it. The dependency court judge is aware of it. The dependency court master was a master here in Philadelphia. He's really familiar with these cases, and he has never refused to give these cases a hearing, approve them to allow you to go in front of the common pleas judge. He always allows it.
There is a legal question which does apply to all the counties, though. It depends on who your client is. If you're representing a lone parent, let's say mom is here, or actually what I'm doing now, dad is here, mom is still in Honduras, I can't go to dependency court.
That's true.
Because the dependency court standard is the child must be without all parental care and control. So it's not the immigration standard we've looked at. You can do an SIJ application if they only have one parent, and one parent, the other parent is abused, abandoned, neglected. Not the case to get in dependency court. You can't have any good parents left. Good. Okay, so then you'd have to go to DR.
So dependency court is only if the child has no mother or father and he's with or she's with an uncle, an aunt, a brother, a sister, anybody other than a mother or father. If there's a mother or father, your petition will get dismissed. You won't be given a hearing.
But it's different in Bucks County.
That's right.
I never file in dependency court because I know the judges up there will not be inclined to grant my private petition. I'm better filing custody in family court because our judges look at the statute very strictly in dependency court. And even if a child is placed with another relative or an adult, they will not consider that as meeting the standard of without a parent or guardian. So even though I don't have a court order, they're very rigid. So it's better off in family court for custody.
We have a question.
You said in Chester County, avoid DR court if you can because your petition's likely to get dismissed. Is that true? So if a client has one parent, if it's a single parent SIJ, and they're in Chester County, does that mean they're out of luck basically?
Well, it's a problem. I talked to the family court administrator yesterday, and she's pretty much the crossing guard who decides, and she controls, whether you're going to get in front of a judge or not. So, or whether it's going to get dismissed. If you are if your client if the child is with a non-parent, it will probably get dismissed unless you can prove in loco parentis, which is the child has to have been with that person at least 6 months. And then the other problem in our custody court is, in every custody court, no one other than a parent has standing in custody court, right? I mean, that's what the statute says.
Well,
Unless they're in loco parentis.
Or a grandparent.
And so you have to consider the fact that also in Chester County, and I don't know about other counties, our masters are not permitted, they're not authorized to make findings of fact. So for them to make these findings that are required by the order, that is out of their jurisdiction, that's out of their authority. So what you would do if your child is with a parent, one of the parents, you would go for a master's. You'd have to have the conciliation conference in front of the master. That's required. You would get custody if you can prove service on the parent in the home country. You have to prove service, and you're going to get what you want in terms of custody, but you're not going to get the language. So then what you would have to do is have a custody trial, and you would then present your case and ask for these findings. Ask the judge. Your proposed order would have your findings that you need for immigration court. So that would have to be done in front of a custody judge at a common pleas level, not in front of the master. And I know it can be done other ways in other counties, but that's most likely. I haven't done one like that with custody court, so I can only say this is based on the information I've received from family court.
Stephanie, that's not what happened in Philadelphia. You don't have to go through a two-stage process at all in Philly. Don't you just file for custody?
Well, you file for custody. It's not clear if you have to go to the master in Philly. The earlier set of SIJs that I did starting back in 2009 were actually all for Dominican kids. And back then, I don't know if you remember, if you filed as a petition to confirm, it would just go straight to a judge. That's just, any petition to confirm would just go straight to a judge. I don't think it's, we have a big backlog of custody cases in Philadelphia. There's all types of problems, which I know the court's working on. I don't know if it would go to a master now or not. I've got to call in to the supervising judge's office. We're going to be talking about this
Well, it
as there's
looks
more
like
and more
you,
cases. But
looks like you got an expedited on the one, didn't you?
yeah, and I will, I'm gonna talk about that more when we get to domestic relations. I've done them as expedited. I got an emergency ones. What you should walk away with today is you have to be creative in family court. Mm-hmm. Think about how to approach it. Service is creative. Which court we're going to go to is creative, and that's in large part is not an indictment of any particular court, but the family law is subjective. The best interest of the child. That's not a hard and firm definition. It's fact dependent, right? So family law is subjective, so you have to think subjectively and creatively. And I think we had another question.
I'm completely new to family stuff in Pennsylvania. I'm really, really confused about the various court names that you guys keep throwing around. It's domestic. Someone say what
court
is.
We're using that as a catch-all. Probably
for both courts.
3 different
Yes,
courts.
just think of family court, and it has 2 divisions.
Okay.
Dependency, which is the child is without his parents or her parents.
It's what you think of when you see a child being, somebody's beating them in the street, you make a call.
Care, right?
Like
So the usual thing they're doing is foster
You
care,
think of
and
a
that's abuse and
caseworker
neglect.
from, Department of Human Services or something. That's dependency court, or a runaway child. That's, to give you a more concrete example, that would be dependency court.
Is there another name for dependency court?
Juvenile court.
DHS court. Some people
Juvenile
call it
court.
juvenile. Now you got to understand, Philadelphia is a large city, so we have dependency court at one address, even though there's soon going to be a same address, and we have domestic relations court. Think of it as divorce court. So they're at different places. Now that's not the case in the counties.
We actually have juvenile court and dependency court. Juvenile court is juvenile criminal cases. In Chester County, that's what we call juvenile court. But in the statutes, they refer to dependency court and juvenile criminal court under one umbrella.
Right. The family law is 23, section 23 of the statutes, if you want 23 section whatever, 5300s. The Juvenile Act is 42? 42. So these are different acts, basically. So even if you're in a county with one judge, for example, the judge would be applying different acts to the type, depending on the type of case. And the biggest difference with these cases, you can't go to dependency court under the Juvenile Act 42, blah, 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 if the caregiver you're representing, or if the caregiver's a parent, you can't go there. You have to try it in domestic relations court. And if you're in a county, such as Chester County, where that doesn't work well, all I can say is jurisdiction in Pennsylvania by the county is 6 months.
So part of it is, I think, the takeaway again is that it's different in every place, and we use different terminology, and we have different names for agencies, and, the takeaway is that if you're going to be doing something in Chester or Bucks or Philly, you want to talk to somebody who's done it there. And the other takeaway that's important is that the filing is not determined, right? Even as we say, well, you'd only do it because you don't have a parent or because you do have a parent. Even that, there are exceptions to, as folks sort of up here are nodding their heads. And so the major thing, just to understand for those who are entirely new to the family law world, is I think going back to Kathy's sort of synopsis of it, right? You have one branch, which is that the state is somehow involved, right? There's state intervention into the family's autonomy. That generally is talked about as foster care. That's the abuse and neglect and abandonment courts that adjudicate and decide that. And then there's private parties having debates and contests and litigation about the structure of the family. And that's custody and divorce and guardianship. So at a very basic level that I know there are lots of exceptions to, that's how we're distinguishing the two. And for you, that becomes who's your client. Is your client the guardian / parent, or is your client the child?
And the statute citations, the Juvenile Act is 42 PACS sections 6301 at sequence.
And it's on one of our slides somewhere.
Yeah.
Justin.
Sorry. And the Custody Act is
23. Title 23, starting 5300s.
So we're going to go now through.
Stay there.
There's been some mention though of orphans court too.
Orphans court
Would
is
orphans
another
court
option.
would that have jurisdiction where sort of like dependency court, there's no parent and
Yes.
there's someone other than a parent that wants to have guardianship of the child?
Yes.
I mean, is that a viable option or not?
It is. Yes, I know attorneys have gone through orphans court and sought guardianship and gotten the special language in the order from the judge who was presiding in orphans court, and that works in Chester County. Technically, I don't know that a parent is the person I don't know what would happen if you filed in orphans court and you're the mother or the father and you're seeking to be given guardianship. You're the mother or the father. You already have that. So I don't know how that would be viewed by an orphans court, if it would even
You
get.
wouldn't do it that way.
It might get dismissed without even getting a hearing.
Yeah, I was thinking it was an alternative to
It is an alternative
to the dependency court.
But dependency, I'm only speaking for Chester County, and dependency court is pretty familiar with these cases now, and Villanova did a lot of the farm worker clinic at Villanova. Kudos to Beth Lyon to sort of, pave the way. So in the previous dependency court judge in Chester County was familiar with them. The new dependency court judge is familiar with them. So that would be I would say the better option is to go through dependency court rather than through orphans court.
We haven't mentioned Montgomery County, by the way. Montgomery County, I think, is feeling.
Oh, I was just going to say, I recently did it in Montgomery through custody, and if it works the way it's supposed to, it'll all go to Judge Wall. You won't have to go to conciliator. You won't have to go to master. Go straight to Judge Wall. She's sympathetic. She understands how SIJ works.
How do you do that?
In family court.
This is
Regular.
DR, domestic.
Yeah, sorry.
How do you,
Think of divorces.
How do you get around all the parenting classes and all that stuff when you file electronically in Montgomery County?
Do not file electronically in Montgomery County.
Montgomery
go in
County
person.
seems to be fairly progressive on this issue. They're the only county, I think, right now that has a special judge designated. I don't even know who it is. Somebody's on the ball out there.
Judge
Judge
Wall.
Wall.
Yeah, did she
Wall.
do it herself?
Yeah.
Okay.
And you are not supposed to file it electronically if you want to actually have it work.
All right.
Go to her.
Because you do have electronic filing in Montgomery County, unlike the other counties. So, but you're not required to file electronically. So you'll be in good shape if your client happens to be in Montgomery County.
So before we, I'm sorry, I don't want to interrupt, but before we kind of move on to just like substantively, like filing custody versus custody versus dependency, and we're going to try to speak generally under PA law what that's all about. But I do just want to mention, you don't have it in front of you now unless you printed it out. But in the PDF materials that got sent out yesterday, we have like a cheat sheet that got put together by attorneys that do these cases in different counties with just some quick notes on Montgomery versus Chester versus Bucks versus Philadelphia, which procedure is best and how to file it. And then again, as Steph and Kara said, this room has a lot of people in it that have done these in different cases, and HIAS has done a lot of these on the immigration end, so we can kind of be a coordinating resource for putting people in touch with attorneys that have done this work in different counties for the specifics when you guys have questions.
And we are going to try, I think, to get all the judges in all the 5 counties who do family court and dependency court to sit down. I know we talked about that, so that we can try and create some uniformity in southeastern Pennsylvania with these cases, so that people aren't thinking, well, I'm in this county, where should I file this? So there's judges. I think we want to reach out to the judges would be the next step in this.
And I think those movements are actually going on in some of the individual counties too. Like I've been briefly in touch with Philly. Judy and Barbara are talking with Bucks, and I think they might be close to being the second to come in to have a designated judge to hear these. We should.
Okay, so let's
get back to our
let's
outline.
move on and getting into some of the substantive piece. So what we're going to talk about now is if you are essentially the child advocate representing the child in this case, that's your client, and you're going to move forward with trying to file a petition in dependency court, okay, also referred to as family court, courts where they adjudicate abuse and neglect. This is what you're going to be working with, right? The statute is 6302, and you see the statute defines it as who is a dependent child. And that's someone who, up until the age of 18, when a child would reach the legal age of majority, you have someone who is without proper care or control. And then it, implicates all three things that we'd want to be concerned about with a child's development, both their physical, their mental, and their emotional health. They also have a subset if there's abandonment, and we can talk a little bit about how you would prove abandonment by the parent or guardian and has been adjudicated dependent. So if we go to the next slide, what this means is that you're going to have to elicit from your client examples and figure out exactly what went on with their parents in the country of origin. You need to be very, very expansive in this, okay, in a lot of ways, and we'll talk about towards the end of the presentation some of the issues that come up in interviewing children and talking with them about their experiences, particularly in talking about something that may be traumatic, that they may not remember, they may have difficulty remembering either because of their age, language barriers, cognitive difficulties, or just the impact of trauma on your memory recollection. So when you're thinking about how to get at all of the causes of action that would fulfill a dependency petition, you have to be very, very creative. And I think also know that there's an investment of time that you have to take. It's not going to be on the first meeting with a child client that you're going to get everything. It generally takes multiple interviews to understand the client's story. So for example, abandonment could be very simply that the young person has not seen their parent in any number of years. There's been no financial support. There's been no emotional support. Obviously, physical abuse would rise to the level that would make a child dependent. That could be examples of the child remembering using uses of excessive corporal punishment. That could include any sort of use of belts, punching, any other item to abuse a child. Emotional abuse, it's not up there, but I would of course include sexual abuse in that. Substance abuse by one or more of the parents or caregivers in the country of origin. That will include also alcohol abuse, right, in addition to drug abuse. Thinking about what is the child's lack, did they have a lack of access to food, to proper housing, to medical care, to education? Oftentimes we're seeing clients who are coming in as teenagers, they stopped going to school when they were 11 or 12. They were forced to work. Thinking about how you can create a narrative, because as Stephanie mentioned, best interest is a very sort of wide standing, and you want to give your client's story in this petition. So if they had to stop going to school, were the working conditions dangerous? Did they have any supervision? Did they have access to medical care? All of those issues can come together to hopefully get you to the statutory minimum to allege that there are in fact grounds to adjudicate this child dependent. As we mentioned earlier, if you're going the dependency court route, right, that family court route, you need to do a special petition in order to file the private petition, and you need to have your private petition, which generally will include an affidavit from your client. Be mindful that whatever affidavit from your client, obviously they'll have to testify to in open court, and so you want to make sure that the child will be able and willing to testify to that. I've often found that my clients underestimate that impact of being in court, and so when they talk about something in very stark terms, very dramatic terms, sometimes they'll get to court and they'll minimize, which is the exact opposite, of course, of what you want the young person doing at that moment. And we'll talk a little bit more again about preparing to testify, but I highlight it for you here.
I do want to just briefly jump in, like Kara clears her throat. Each case is different too. Yeah. The sample petition you were emailed yesterday is actually the first dependency one I did. My client didn't have to testify a bit. His situation was, though, that everybody was deceased. So, and he just didn't have anyone else, and so he hopped a plane to Guatemala and came on up. So it does depend. So in terms of, especially if you're a pro bono attorney, you think, oh my goodness, what have I gotten myself into? It really depends on the facts. And it depends on the judge you get.
It does. And in Chester County, twice she wanted to briefly hear from the child, and twice, and once she said, I've read it all in the petition, I know what he endured. And with the kids that I've represented, they've had all of the above. They've been abused, they've been abandoned, they've been forced to work, they've been thrown out of the house, and so, you know, it was every single category. But the person who will have to testify is the petitioner, which is the person who wants to be the custodian. That person in Chester County will be heard from, but the judge will want to hear from that person because that's who she's giving custody to in a dependency setting.
So another exception is that in Philadelphia County, often they will only have the child testify and not the guardian. So again, we sort of underscore the regional.
Although I had the guardians, my judge only wanted to hear from the guardian.
Right.
The young man was there, but he was a semi-pro baseball player, so the judge actually only talked to him about baseball, quite frankly. But, he got a college scholarship to University of Colorado. He's doing very well now.
We also appoint guardian ad litems in Chester County for every child in dependency court, so that there will be an attorney who's a county, it's a list of county attorneys who, this is all they do, they're guardian ad litems, they're paid by the county, and they will want to meet with the child. They may want to see the child where the child's living. They won't want the attorney there when they meet with the child. They're going to talk about the condition of the home and if the person he's living with, if it's a brother, an uncle, whoever, is a good parent, and so forth. And they will want to. The guardian ad litem will make a recommendation that this is the appropriate person for the child to be living with. So, one thing you have to be careful about with these children is that they are enrolled and attending school. If the children are not going to school, and we've had children who have come to us for the SIJ and they don't want to go to school because they're desperate to make money and send it home to starving brothers and sisters, and they just don't want to go to school. And they have to go to school, or this isn't going to work. At least not in my county through dependency.
I think that's
court.
uniform.
That's
you better be in school. I lectured a young man on Friday.
And this may be jumping the gun, but since you mentioned the guardians ad litem in Chester County, in dependency court in Philadelphia, for example, usually the DHS would do like a background check on the guardian, and there'd have to be all kind of clearances of the proposed guardian. Is that done in these kind of cases since it's a private, or is it done away with because it's a private filing?
I didn't have it done as a private filing by my people.
We haven't had it, although there's oftentimes if the young person was placed through the Office of OR, there may have been a home study done, and we will reference that. But I think it also gets us to, when we think about DHS and CYS's roles, right, one of the things that, at least and it sounded like for Chester it was as well, we do have, whether it's out of courtesy or just the process that has arisen, we do always contact DHS here, the Child Welfare Agency in Philadelphia, to say we're asking for the court to approve this private petition. We're not requesting services. We want to give you the heads up. If you have any objections, let us know. I've never had a case where they've raised an objection. They will generally, on the record, say we're not a party to this proceeding, and so they will sit silently because they're sitting at that table all day. And this proceeds simply with the U.S. counsel and then the guardian, and whether or not
they show up, but they don't
speak,
really say anything.
And I just have a quick technical question. I know for agency filings, the AOPC has set forms that you need to use. That's the same for private petitions as well.
Chester County used the AOPC form. It's right on the AOPC.org website, which is in the materials, the website. And it's great. You can go on there and you can fill it all in. But for the application to file the private dependency petition, you have to do an actual petition.
Right.
But it doesn't have to be that elaborate. It's very similar to the pre-printed Philadelphia form. It's just that we don't accept, a pre-printed form on a private dependency application to file a private dependency petition.
A question? I have a couple. So the document from the court order that we're seeking, what is the name of that court order from family court?
We're gonna get to that if we ever get there in a few minutes.
So is that twofold? It has to. We're trying to have an official guardian appointed to that child, and then we're also trying to get that immigration language.
All in one.
No, wait. It depends on what court you're talking about. In dependency court, the child always has a child advocate. It's just any child, any case will have a child advocate. An attorney for the child is appointed, and we could debate whether they act more as a guardian ad litem or a child advocate. But anyway, the child has a person. Now, for this project, you could be going in to dependency court as the child advocate already, so you're that person, depending on who you're representing and how it's set up. In family court, although Karen and I are sitting here debating this, you may or may not have
action in family court if you're the advocate.
Well, Karen's going to talk about that in a minute because told me about something I didn't think was possible. But at any rate, so it depends. But you're just getting an order. One way to, this is really just a custody case. For those family law practitioners, this is just a dependency case. This is just a custody case. And it's good to let the bench think that. Liz and I were involved in a court's presentation. That's where these materials are from, actually, Philadelphia Inn of Court. And that's what we were trying to convey. This is just a custody case. Make the findings you'd otherwise have to make, do service. It's just a dependency case. Don't get freaked out because you think it's something special. It's not. You know how to do this, okay? So you're just looking for an order. You just want particular findings to be made. And then you may need, in a different type of custody case, you may need other findings to be made about relocation or school choice, whatever it may be. You've got rich parents who can't decide where to send their kid, for example.
And oftentimes for the dependency court, they have sort of automated orders, right? That they are plugging in. The clerk is sitting and plugging in, and so we sometimes call it the special findings order because it's just on another piece of paper, and we draft it in advance because they couldn't do it.
You don't want just that order.
Right.
That order's not going to.
That order probably won't cut it in immigration, and so what we do is, it's not to say that it's a totally different order, it's out of whack, it's just, Your Honor, we're asking for it to sort of go in this particular order to assist
an addendum,
our client. An addendum. And generally that has, and they're used to it in Philadelphia and other counties where this is newer. I'm sure that may raise some issues that, again, normalizing and minimizing the distinctions in the order is probably your best strategy in the back.
But going back to the dependency situation, two related questions. First, I'm assuming you're just going for dependency. You're not going for a termination of rights.
Oh, no.
Just a declaration. Okay. But even in a declaration of dependency, don't you usually have to serve the parents?
Yes.
And what do you do with service?
We're going to get to service later.
Okay.
Lots of service.
And you can even go to the next slide, which is going to give you.
And should we go around the table with questions?
Yeah. So I think there's in the blue shirt and then.
No, it was about service. So if you're going to talk about service.
Okay. All right.
I do have one question about the sole parent who is filing for the child. What if that person's out of status? Does that ever come up? Is that a big issue?
Not for me in dependency court. It's never been asked. It was asked maybe by a guardian ad litem appointed by the court, and just in passing. It wasn't. Really.
The only time I've ever had a judge had it come up in a case in Philly was the sheriff actually took notice, and the judge was kind enough, a very kind judge, to say, "Oh, Mr. Sheriff, let me talk to you." And I had it come up another time, an extremely stupid opposing counsel who said that his client could not pay for child support, Your Honor, because he's here illegally.
Oh, wow.
And I've been practicing in Philly for 20 years, so that's twice it's come up in Philly. They're too busy. They have other things to worry about, It's a busy place.
You're using custody and dependency sort of interchangeably, but you also have distinguished between dependency and custody.
They're very separate proceedings. Different standards, different rules, different statutes. They're different things. But they're both can get you where you need to go.
Different courts, but you're still looking for the same
order.
Exactly.
Yes.
Exactly.
So it's like,
right,
okay, I got to get here.
Right. So this order, right? I mean, there have even been attorneys who have gone through the delinquency proceedings to get that special findings order. Okay. So there are multiple venues and routes to get that order, but what you ultimately need is an order. And right, the sort of the thing that ties all of our courts together is they have the authority to determine what is in a child's best interest. Why you're getting there, whether it's a mom and dad fighting for custody, or the state coming in and saying that a parent is not fit to take care of their child, ultimately they're talking about the best interest for this child, which is, I think, why it's housed in the local courts. Other questions? Yeah.
It says every 90 days. That means you have to go back to court every 90 days?
So that's Philly.
Or not always, though.
Right.
Not in Chester
Not
County.
always in Philly. Depends kind of what your circumstances are.
Retains jurisdiction, but they don't schedule anything after the order is signed.
This is actually a question for the immigration attorneys. As Judy and Barbara are talking out for Bucks County. Bucks County doesn't like to say we retain jurisdiction. The other counties will. But it's a matter
In some
of
cases, they do retain
maybe they will.
jurisdiction. Yeah.
Right. But it's a matter of law. If you were to read the custody statute and say who has jurisdiction, the law would be clear that it's that court. So I don't know if that would work for our immigration attorneys. If we couldn't get that language in the family law order, then you could simply take the statute and say, well, it is this court. They must retain jurisdiction unless somebody moves, and then.
Yeah, and from my perspective as an immigration lawyer, we recommend if the court is willing to just put that line in the order, this court retains jurisdiction, that's clear and easy for us. It's right there. USCIS can't question it. We filed them certainly where, for whatever reason, that line was not in the order, and we haven't had CIS challenge us at all on that particular issue. Okay.
Earlier you're talking about like telling judges don't freak out because it's all the same.
Maybe that's
in a
me.
nicer way.
Yes. Well, no, I've said that, but it's like,
from the civil field, because I do civil litigation. Every settlement agreement I ever have always says court retains jurisdiction to enforce. I mean, is it different with family courts? They don't family court. It seems like I've never met a judge that didn't want to retain power to enforce whatever that court was going to say is going to happen.
I think there's more to it for family. I mean, I think.
But, I'm sorry. There's difference between retaining jurisdiction for enforcement purposes and, I mean, you got to think about family court custody. Anything could happen with this kid next year. The girl's pregnant next year. Who knows? And somebody else wants custody. Family law never is over until the kids are a certain age. So the courts may not necessarily wish, especially if it's a really ugly case, maybe they don't want to, but it's not the same as just keeping it for purposes of enforcement. But there is a statute about this. It's Liz is saying it's okay. If you don't get that little piece, it's okay. In Philadelphia, it's pre-printed on the orders. You can't relocate unless blah, 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 which implies the jurisdiction. They retain jurisdiction. You can't get an order without that language, even if you want one. So it just comes out.
Steph, I have an issue. If you have a situation where the mother wants to get a custody order for the child, but the mother's illegal, recently someone said that they couldn't, the parents can't get status through the children. Is there any problem with filing on behalf of a mother who brought a young child here if they've lived in Pennsylvania for 6 months?
No.
Well, no.
Just like any custody case, nobody's going to ask about the
you don't have to
status
worry
of the
about that then.
And you don't even have to have 6 months necessarily. Because if you look at the custody statute, right? Maybe we should. Let's finish up dependency really quick and then move to domestic relations. We'll get to service.
We'll get to service. So just for the dependency filing, and I think we've sort of gotten at this as we've been talking, right? And again, it's different, but what you're essentially doing is you're going to draft that petition, your client's affidavit. You are going to have to request special permission. Jurisdictions differ, but at some point you're going to get a court date.
You'll get 2 in Chester County,
Exactly.
but the first one is just really fast, and you don't have any testimony. You're just going in front of the master and saying, please sign this order allowing me, recommend that I may be given an opportunity to have a hearing in front of a competent judge. And as long as everything looks right, he'll just sign it. It'll be 5 minutes.
And in Philadelphia, you will not have to have that hearing at all. That happens behind closed doors, and you will get an email from the clerk of the court essentially giving you a couple of dates and times to choose from, which is nice because then you can actually have it accommodate your schedule. And at that point, once you know there's a court date, and again, it's judge specific, so it's county specific, and then it sounds like it's also very judge specific of whether or not the client will be required to testify. And so you want to reach out to folks who have done this before to know how much you have to prepare your client. At a minimum, you have to prepare your client for walking into family court, and we'll talk about that towards the end. And then when you're in court, if there has to be an argument about what we're calling the magic language order or the special findings order, that would be what you want to ultimately come out of that court date with, because that's going to be critical for their immigration application.
Just in terms of materials, just 1 second, Audrey. There is a sample dependency petition Kara was talking about. This was in the materials from yesterday. This is my baseball player. You do need to be extremely specific about what happened, and he was left with his 88-year-old great-grandmother who can't take care of him anymore, and blah, blah, blah. So you have to be, I mean, I'm verbose, so this is easy for me, but some civil litigators aren't accustomed to this.
I do really long ones
Yeah.
too.
This one actually wasn't that long because this child didn't really experience any abuse and neglect. He just had, there was no relatives left. He had 7 U.S. citizen uncles and aunts here, and his grandmother here. No one was left in the DR.
But I think the other advice I think we'd all give is oftentimes including more, right, in the petition, in the affidavit, is going to save you time when you get to court, right? They are reading these, and I think if they know the particular traumas that your clients have gone through, they're not going to question them, hopefully, about that, unless it's a judge who really feels like they have to have a record of the oral testimony for that. And so put in as much as you can, be creative, and obviously we haven't talked about, but if there's any supporting documentation that you can get, also be creative about what will allow the judge to say it's not in their best interest to go home and it's in their best interest to stay. So example of, reports from the school. We've had folks write letters on behalf of our clients to have ready to go to the judge if they need that. We had one young person who was in the ROTC and was the exemplary ROTC cadet of the month. That's all good stuff to be showing the judge as well, and take a prospective, forward-looking approach in your petition as well.
And with the petition, at least in Chester County, I always attach the documents that came from, usually the kids we've seen have been in Texas or Arizona, and the shelters give them their discharge papers, and I attach those as exhibits along with the birth certificate. It's in their Spanish usually, and the judge doesn't care. She just wants to make sure this child is still within her jurisdiction because he's under 18. And all the kids have had birth certificates. I know someone asked that question this morning. There hasn't been a child yet we've seen who didn't have. That's what they have, those birth certificates, and they're. But I attached the refugee, the letter, because it shows this is not. We're not asking. This is a refugee. Okay, this is a special kind of person here who's been given special kind of status already, at the border.
The other thing I attach as an exhibit is that list that says frequently asked questions by state judges, because they do read these petitions, and it usually bypasses a lot of the questions they may ask if that's included as an exhibit.
In the materials you received yesterday, there's two pages, I think, that Liz attached, frequently asked questions for state court judges. There's also this lovely brochure that was in your materials. So I've never attached them, because I hadn't seen them until Liz gave it to me, but they are great. We're gonna jump around a little bit. We're gonna quickly roll, because we've been talking a lot already about dependence. Audrey, wait a minute, you had a question.
Yeah, just in terms of preparing for court. I know you're going to get to service, but for serving other countries, etc. How much time, and I'm sure it varies by county, but from when you do file the permission to file, when do you usually get a court date typically?
In dependency, when you file permission to file, because you wouldn't be doing that in custody. In dependency, when you file, those dates are fairly quick, I think, in any of the courts. It's going to be rolling.
In Chester County, you can say, because you have to go to the judge's chambers and get once you get the permission, you can get right away, and you want that right away, because then you know that you're able to proceed further. Once you get that permission from the master, then you go to the judge's chambers with your rule, which is going to give you your court date. She has to sign off on it. She's the only one who can give you your court date, and you can say to her secretary, please don't do it too quickly, because I have to get service in Guatemala or Honduras or wherever, and they can put it out as much as 30 days.
Or alternatively, please do this quickly because my client is about to turn 18.
Right.
And they've been very, very helpful with that in Philadelphia Family Court, because oftentimes you're up against the age out issue. The general, assuming there's no age out issue or no special request because of service problems that may arise, I found it's anywhere from 3 to 5 weeks, right? For Philly, just talking about Philly now, where you sort of get the approval and then you're given a choice of weeks. But I have to say, they're very accommodating.
And remember, dependency court is fast because you have a child who's without anybody taking care of him or her.
Yes, by definition, that's why you're at dependency court. There's no available parents. This is a child who's in trouble, whether this is an SIJ case or just any child here in Philadelphia.
Will you be giving us people in Honduras, Nicaragua, whatever, who can serve these papers?
I'm gonna breeze through domestic relations because everyone wants to talk about service, and it's very interesting. In the stuff you received yesterday, by email. You have several sample custody petitions, and thanks to Sarah Katz, who provided one of these. These are different. It's just a regular old custody petition, okay? But we have samples being provided by different people, okay? The first one is, I did this when I just finished this kid up a couple of weeks ago. It was his maternal aunt. It's one of my Dominican kids, okay? And just like any other maternal aunt, he'd been living with her. She filed. It's just a regular old custody petition. Sarah included one on behalf of a mother, alleging that the father in the home country had been abusive to her and the child. And Sarah got this one through as well. These are all successful petitions, by the way. The third one, this is, and you can see Sarah's name. Oh, Sarah also included a translation, because when you make service, you need to send the documents in the proper language. Then the final one, I actually did as a pro se. This was actually my client, but this is an example of a child who was turning 18 very quickly, and we have a big backlog here in Philadelphia. So this is the one that looks funny. It's all handwritten. This was for a child he's going to be 18 in January, so we had to hustle. I actually did the fill in the blank forms, and they filed pro se and got a date because I didn't have time to make it look nice. I just handwrote, said, here, go file this. And then once we got to the date, I went to court. So there are different procedures in each county if you need to be in a hurry because the child's going to be 18 soon. And I don't think we have time at the moment to go into that, but every county has some form of procedure. The question is whether or not the court will consider the fact that your child's turning 18 and can't file the immigration application to be an emergency. That's the problem. Not all judges will.
Not in Chester County, sorry.
There you go. So don't try it in Chester.
And we'll get dismissed.
I've had it done twice now in Bucks.
All right. Delaware works. This expedited went in Philly. It's particularly important in Philly because right now, since June, I believe, Joni, Elaine, since May, anybody who has filed a regular custody complaint in Philadelphia has not been even given a date.
Now they do. Okay,
All of a
now
sudden?
they do.
All of a
Yeah,
sudden?
because
Okay.
we made a lot of noise. So, but it doesn't make sense because some are in December and some are in June.
Right.
And you
For a
know-
while there, they were an entire year out just to get to a master. So things are a bit iffy in Philadelphia. So if you're filing for a regular old custody case in Philly, you might need to be creative about satisfying to the court that you meet the expedited standard for other reasons, or the kid, even your 16-year-old, is going to be 18 by the time you finish. So you need to talk to a Philly practitioner about that particular issue. So you had this kid, and this was his paternal uncle. And as you can see, the allegations themselves, they said I did it pro se. That's all I put. But I hit the major points. Father beats up mom. Child tries to defend mommy. Child gets beat up himself. Boom. If you look today you received a little packet. This is actually that kid's order, which I got on Friday. On the top part of it, look at the last two pages of the packet. The top is service, and we're talking about service in just a second. So I did get service. I went through the process. This particular judge, she assisted in presenting at the end of court. She's now extra educated. She read the fact frequently asked questions sheet. She liked her brochure. Nice lady. So she went through and she conducted it, and this is how she thinks about it. I have to conduct a custody case. I have to find out what's happened to this child. So she went through. We went through service. She made findings as to service. She made findings that the paternal uncle, in this case, has standing because the child's been living with him. She made findings. She took testimony. She took almost no testimony from my client, the uncle. She just took she read the pleadings and an offer of proof from me as to what my client would testify to, because he did know a little bit about his drunken brother back in Honduras. But she kept the 17-year-old in there and threw the rest of us out. And I don't know asked what, but it went well. So, and so she made specific findings here because she's aware that we need a little bit of specificity. The child was abused and neglected while in the custody of his parents due to the abuse by father of mother and the child. So she said specifically, I took testimony. And this is what I think happened. And then she put specifically, reunification with father and mother is not viable due to abuse. And she then went as far as to say, well, he can't return to Honduras. There's no caregiver for him there. So it is not in his best interest. So I did have in Philadelphia County, they type all their orders in, but I did go with a proposed order and said, Judge, here, let's do, based on whatever you spoke to about the child, let's do this, and this paragraph. Now, she wasn't just doing me a favor. She was even though I know her, she was putting me through the motions. I mean, she went through all of it.
So was that a custody trial that you had?
Normally, it was. In Philadelphia, when you go on an expedited emergency, it's not supposed to be the full trial. It's supposed to be, okay, we need to stabilize the situation for this child temporarily, then you'll get your regular date. But because I was clear about this child's going to be 18, Your Honor, might we have some findings today? She did.
But what if the child was 16? Would you have gotten the same thing from a master? Or you don't have masters in Philadelphia?
We do have masters in Philadelphia. No, we couldn't have gotten it from a master.
So you're in the same situation as...
Well, I don't know. Not necessarily, because, for example, in one of the petitions, the one written by Sarah Katz, what she did to bypass the master, that child wasn't about to age out, but she wrote to the supervising judge, Judge Murphy, and said, this situation, blah, 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 might you please schedule it differently?
Well,
and that worked.
I don't want people who get these cases, I don't want people to shy away from taking cases volunteering in Chester County if the parent is involved, if it's a mother or father that has a child, because just because you can't get your order from the master doesn't mean you can't then proceed in front of the common pleas judge and explain the situation, because I don't do custody practice in Chester County, but I see a Chester County lawyer in here who does, and I think there's a possible pretrial conference or something, or how does that, if it's just one parent and you got your custody award in front of the master, but what you really want are the findings of fact that the master can't do because he can't take evidence.
I have never tried it, but I venture to say that what I do in those cases is try to get sole physical and legal custody so that the parent in the U.S. can act on behalf of the child. I haven't tried it, but I'm sure that if you tell the master the special conditions of the recommended order to put that language, I bet you that they'll do it.
So you think, so that is something to try. And there is a place on the form orders for the masters to put special conditions. I don't know what would happen once it goes up to the signing judge. It might.
I think if it goes up as a recommended order, they'll just sign it.
Yeah, because they can just sign it.
You know,
So
especially when they're giving the parent in the U.S. sole physical and legal custody, who cares if we're going to add those two conditions?
So try it. I mean, I haven't had one yet so I haven't had the opportunity, but I'm going to try it if it comes up. I'm going to just try it right in front of the master and see if he'll or she will write it right on the thing.
Yeah, when in doubt, ask. Can't hurt.
If there's nobody there to oppose it, why can't they just write it in there?
Well, what I do is, because Bucks County does not have pre-made orders, I always prepare the proposed order with my petition, and when we go to the master just makes a recommendation as to whether the order should be granted or not. They don't have a pre-form.
Okay.
So when we get to the judge, and the judge is ready to enter the order, I say, Your Honor, I have the order attached to the petition, and the judge just pulls it right out then and signs off on it.
And now, and to that end, so this you were given to today. This is a nice, after actually discussions with Liz, and these days with the surge of SIJ cases, thinking let's try to get a little more in the order from the judges. So this is, I wouldn't necessarily have gone to these quite this far before, but you have in the materials from yesterday, it's called the magic language order. No matter where you are, in dependency or in regular custody DR court, these are kind of the minimum things you want to get. So if you're in a county where you have to prepare a recommended order yourself, this is what you need. It's very straightforward. Okay?
So for immigration purposes, regardless of whether the process was started through traditional family court custody or dependency, so long as we have the magic language in the order, we're good.
Right.
Yes. So this is your goal. This one piece of paper. Get this with some nice embellishment, if you can. But this is what you want. And this is in the materials that were emailed yesterday.
Just wondering if anyone has discussed doing this in stipulation.
outside of Philadelphia.
Yeah, that's what I would say.
Yeah, I don't know. Oh, yeah, I didn't mention that. Yeah, there have been stipulations. Philly has accepted stipulations. The one done by Sarah Katz was actually mother and father agreed to it, and Judge Murphy just signed an order, which normally in a custody case, if the parties agree, you just get an order signed. I don't know if that ever, I don't know if that's happened out of.
We have a lot of success with stipulated custody orders and actually attached an affidavit, and the child never had to testify in court. It was stipulated, and I think I don't know about the other counties, but for our order, it was very detailed why there was the theory of neglect, why the court had jurisdiction, the child had lived there for 6 months, and it was like a week. Like, stipulated, turned back to us, and everything was terminated with it.
And by stipulation, what we're talking about is mother, that would be where, well, most likely would be where you're representing a parent, and the other parent is willing to sign off, or not. You could have the paternal uncle, and his brother could have signed, and yes, I'm a drunk, and but I don't know. It's very, there could be, and Liz was talking about this, that could raise some suspicion.
Yeah, so the issue
because
is, right.
Who's going to sign? Oh, yes, I'm a drunk. I beat my children. Who's really going to sign that if it's real?
Right. So when you go in front of USCIS, we've actually had plenty of success. I've had cases where the order was obtained by stipulation. We filed them. They've always been approved by CIS. What my fear is, and maybe I'm just being paranoid, is that with this surge of SIJ cases, they're going to start scrutinizing it in more and new and different ways, and that one issue could come up, which is, if the immigration officer is trying to determine what the basis is for the family court order, and is it based on truth, then they could suspect some kind of collusion, and that the information is actually false. So our recommendation was that best case scenario for later immigration purposes is for these orders to be obtained via a hearing with evidence submitted or testimony or whatever. Failing that, knowing that in some family court jurisdictions that's not going to happen, but you could get it through stipulation, then we'll go ahead and try. But in that case, it would be best for the order itself and for the stipulations and everything that's filed to be as detailed as possible.
And remember, the statute, the immigration statute says findings by a judge. And I don't know. I don't know if they ever looked behind what's behind the order that you got from family court. Maybe it might be a problem if the judge never actually took testimony or heard evidence.
So from today's training, we're not recommending you use a stipulation unless for some reason that's all you can get. One other thing, I want to go back to education. Really, they must be going to school. This judge, it's the second time she's done this to me. This young man who's been here a year, if you see at the bottom, he didn't speak at, he's been attending Philly Public School, no question. He's put in 9th grade. And he doesn't speak enough English. She is not doing this out of a bad place. She has 2 teenage sons herself who are this young man's age, and she's actually like, the schools have to help him. He needs to speak more English. And so she's ordered my last one, she ordered the school district to do things, to get the young man an IEP. It was pro bono. I had to go back 4 times. I was ready to shoot myself. But we kept going back until Pilcop was pushed on the school. He's got an IEP now. He's got special ed now. This is beautiful. This young man who doesn't have any special issues, he said, I'm from Honduras. It was very cold last winter. I didn't go to school much. So there you go. So where am I going? Even though I've got all the magic language, I'm going back in January to make sure he's enrolled and how much more money? Some money. It's not pro bono eligible. Get your gloves on. Get your butt to school. Just like I say to my own kids. She absolutely. And I don't know. This is a question. This has never happened to me before. She only issued an interim order only because she wants to come back and check on his English and is he going to school. But the hearing date to come back, so she made it interim, is 5 days after his 18th birthday. So I don't know if I've got to try to get it in before. I don't know if all the findings are here. I don't know if immigration cares that 2 little words here say interim. If you're in Philly, you're probably going to get this.
Yeah,
judge.
no. I mean,
okay.
we filed in similar situations with orders like that, even emergency orders and stuff like that, and they've worked with.
Okay, because it would be analogous to dependency orders where they're going on and on.
I mean,
anyway,
at the time,
right?
and for CIS purposes, the child has to remain subject to the court's jurisdiction unless the reason the child's no longer subject to the court's jurisdiction is because the child's aged out. So that order would have gone through until they were 18, and then it stops because they're 18.
Okay. All right. Service. And we're probably we're going to jump over orphans court, which we talked about a little bit. because Liz tells me we're running out of time. We're jumping straight to service because everybody wants to talk about it. Okay, service. Again, service is just like any other family court case, okay? There's a rule of civil procedure. Here, I will quote it for you. 1930.4, okay? When you have international service, you get additional time to make service usually. But you can make personal service, you can make mail service, assuming there's mail in the place where you're trying to get service. But just think about service as you would make it normally, okay? Now, there is an international treaty. There's a Hague Treaty on service of process. If the country in question is a member of that treaty, then you need to pay attention to the treaty. There's also the Organization of American States, you know, the North and South American version of NATO. They have a treaty about service. Guatemala and Honduras are not members of the Hague Treaty. They are both members of OAS.
Honduras is a member of the Apostille Convention.
But they are a member of the Apostille Convention, but not
Guatemala.
right. But they're not a member of the Hague Treaty on Service of Process. Okay. What you need to walk away with, because neither Honduras, and I forgot to check El Salvador. I haven't done El Salvador. Because neither Honduras
is a member of
OAS, but not.
It's a member of Apostille Convention.
But I don't
know if it's a
Hague
member or
Treaty.
non-member of the Hague. I don't know.
I don't remember. But you can check that. You can go on the State Department website and find out. But for Honduras and Guatemala, they're not members of the Hague. They are members of the OAS, but they have no stated objection to using personal service in their country. Some countries, personal service is just not allowed in their country. So even if they're a member of one of these international treaties, their state, we don't allow personal service in our country. Okay. If you're some attorneys, more experienced attorneys, may have heard of letters rogatory, which is what you used to have to do to get service in other countries. I'm so young, I've never had to do that, but others perhaps have. You don't have to go that far, okay? Because Guatemala and Honduras have not objected to personal service, you can do personal service. You could do mail. Mail just doesn't work most of the time because there's no mail where the left behind parent lives, okay? So now I'm talking about what you can do as service. Be creative, okay? You're not going to call up your local process server and say, oh, please, you know, with a high-paid client, please go make service in wherever, okay? It's not necessarily going to work. However, there may or may not be FedEx service, depends on where they live.
In most of the Central American countries, DHL will do the most decent service you can get.
There's I didn't mean to interrupt, but I just want to tell you, in case you're panicking about service, thanks to Beth Lyon, who is on the board of this organization in New York, it's called the Global Alliance.
Global Workers Justice Alliance. You have to raise your fist.
And they're in New York, and they're fantastic. They have lawyers. I don't know what they call the lawyers in the South defenders stationed all over, I guess, Latin America. And every case I've had, you fill out forms, you tell them what you need them to do as far as service. All the children have known all the parents seem to have cell phones, okay? In Guatemala, Honduras, everybody has
landlines and no house addresses, but people have cell phones.
The addresses are trickier, but you know, you get the cell phone number, you give it to the attorney in Tenango, and he somehow gets these parents to his office, and it's worked every single time. And he takes pictures of them in his office. You say to the child in front of the judge, can you identify the people in this photo that came from the lawyer in Guatemala? Yes, and the judges like it that there's a lawyer on the other end of the, of the documents. Global and
I'm sorry, can you say the name again?
Global Workers Justice Alliance.
And they have a website.
John, we can send out that contact information from our email list too.
So that is a really easy way to do it. It's very inexpensive. And they're very reliable. I haven't had a problem yet. And they've gotten now all the children have been from Guatemala, but I think they're in other.
They're in Guatemala, Honduras, Salvador, and Mexico.
So talk to Beth after the CLE, and she'll tell you. She's on their. You're on their board, right? Yeah. Beth from Villanova Law School.
If you can't And then another method, and this is what we use if you can't get an acceptance of service for some reason, or if your particular judge doesn't want an acceptance of service. Like I think Justin currently has this problem in Lehigh County. The judge says, how do I know that's really the people? Sending the people off to one of these lawyers, again, the lawyer to track them down would be good. In the materials I handed out today, my client, the paternal uncle, knew where his brother and sister-in-law lived. So we actually faxed all the papers down. The Lone Municipal Office had a fax machine. So we faxed them down. They went in. I mean, I don't know if the uncle knew we were going to call him a drunk and a whatever, but it doesn't really matter. All he needs is the papers. He doesn't have to agree with it, right? So they went in. They accepted the fax. So here it is, Spanish and English. I went a little bit further than a regular acceptance of service, which is the reason I handed this out today. Most of you are lawyers, you know how to write an acceptance of service. Yes, I received these papers on such and such a day and such a time. I had them also confirm that they understood the hearing date was going to be on such and such a day. They understood that they had a right to participate in such and such a fashion. They knew the custody of their son could be given to a certain person. I was a little more expansive, which the judge liked, and that's the reason she didn't question my service. So they signed it, and the one fellow, I think, at the municipal office also happens to be basically a justice of the peace, what we would think about. And so he prepared a very standard form, which you might see from Latin American countries, saying so-and-so appeared before me, their national ID number is such and such, think of that as like a social security number. I saw these people, I gave this to them, they signed it, blah, blah, blah. So he kind of did what the lawyers might do, but for a picture.
I do an affidavit of service to be signed by the attorney in Guatemala in both English and Spanish, and he took it upon himself to take the pictures. But we're not translating any of the information in the petition. So
we do.
We don't have to. It doesn't have to be in Spanish. The petition says a lot of things about the parents, usually, that aren't very nice. And I don't know if they, know what's in there. But what they do know that's in Spanish is that there's a case coming up in court on such and such a date, and if you're not there, you're going to lose. There's a good chance you're going to lose custody. And that's what the judge wants to know that the parents saw. And when they aren't in court, she proceeds. But you have to prove to her that they were served. And these affidavits that are filled out, that are signed by the lawyer in that country, and then with the photographs, it's been sufficient.
I think that may depend on your court. For Hague Treaty purposes, if you happen to have a Hague Treaty country, I think you have to translate the initial petition. It's not compliant if you don't. So if you wind up, I think for Guatemala and Honduras, you'll be okay. I would not submit, and that's just my practice. I wouldn't. I translate the petition, and I know Sarah does. But again, it may or may not be required. And Bucks, is it?
Well, I've been a little more creative than you all together.
Yeah. Are you on the donkey?
I have actually, because a lot of my cases involve a child being placed with a parent where the other parent has abandoned, and we don't know where that other parent is.
Yes. Yeah.
I have filed motions for either waiver of service or alternate service, and asked for the ability just to publish in the legal periodical, because obviously if I have a parent that could be residing anywhere in the country, I have no idea what periodical down there to publish in, and I've actually been successful, and the courts have approved those motions.
But isn't that really expensive for the legal?
No, because if I do it in my legal,
in the legal, okay.
It's 65, 70. I don't have
But
to.
that's different by county. I had to do, it was for a divorce, an Indonesian case, and publishing in Delaware County is quite expensive.
Same in Chester.
And that Delaware County judge also made me publish in Indonesia, which was obscenely expensive, my poor man. It was $2,000 to publish twice in Indonesia. So,
publishing in Chester County is by local rule, isn't it?
Yeah, but that's it. You can ask. There are cases where the parent's deceased, okay, or where the parent's address is unknown. So you have to. Now with the dependency example you have my client, the uncle and the young man testified, I haven't heard from my parents and I don't know when. Last I know, they were in New York. And the court just accepted their testimony on that subject and did not make me go further. So it's going to depend on your three categories are, you might have a deceased parent, but missing, you have no idea where they are, or you know where they are, and you have to get creative about how to serve them. And if you don't know where they are, you might take testimony, you might have to have a special motion or some type of creative. Bucks County must have the cheapest publication
They
rates.
do.
Yeah, they do.
Yeah.
Our
So,
legal journal is the least expensive.
I'm going to publish something there. So, but again, it's like any other service, right? Except that you can't hire, process server to go run and tag somebody necessarily. Any other questions about service? We had all these questions, but I hope I've made the point of it is not as difficult as you think. That's way to comment and question. Huh?
There are several areas, and I do custody, so all across from, I don't know, Mexico all the way down, and including the Caribbean. And when I've had issues with service, and this has been very effective, although it's probably not the most orthodox thing to do, is I try to find out which one is the parish in their area, the church in their area. I call or contact somehow the church, whoever is there, and I ask them, do you know this person? More than likely, yes, they do, who know who they are. And I said, is it possible for me to send you legal documents that are coming from from the States, to give them to them? And would you please sign that you actually got them and gave them to the person? And the answer is yes. Now, exactly.
Also, they're small towns.
They're small towns.
They've been willing to even deliver the
Yeah. There are areas, though, of Mexico, especially where the drug traffic is very high, that nobody would do any kind of service whatsoever. Not because they just won't do it, it's because that in the process of doing so, they can get killed. So that's a different situation. I beg your pardon?
Find out the church.
Well, we just call and find out. Usually, and I have a good contact.
You contact a Catholic.
Yeah, you can contact the
They can
Catholic
help
Church.
you.
But the other areas that I have been calling, and they have been very good in assisting, actually from Philadelphia, is the Mexican consulate in Philadelphia. If you can get past the regular call, you have to get somebody's phone number. Otherwise, nobody answers ever. But you can get through, and they will tell you in certain areas, here's a person that you can contact. Here's an area, in that particular section that you're looking for. And sometimes reality is that the mail is dropped in some box, and somebody comes with a donkey, literally comes down the mountain, picks up the ones for the people who live there and so on, and you can't get that type of service.
The mail. The mail is your last resort.
There's another method too, and actually is how I said I faxed these documents down to the municipal department. I got them back with a viajera. In the neighborhoods, and your clients may know viajeras. Viajera's a traveler. So this is a Honduran woman in the neighborhood who takes stuff back and forth. You pay her, I think they paid her $20, and she brought these documents back from Honduras because she happened to be down there. So that's what my clients did.
Your clients will know.
Yeah, you don't need to know. They'll know.
Say this is this person, and the issue there is really timing wise. I've found.
Yeah, you got to find a viajera who's coming back at the right time. And we got lucky. He got it literally dawn. She landed at 5 a.m. on Friday morning, and we were in court on Friday. So I was like,
So can you go to the Nicaraguan, Salvadorian, and Guatemalan embassies here? Or
You can go to the Guatemala. I've had luck with the Guatemalan consul in New York. They have actually taken it was not one of these cases. It was a different kind of case. It was a different matter entirely. But they actually went to the people's home, and in the middle of nowhere, they actually went there. Well, she sent somebody. She didn't go, but she took the documents, and they have this thing called diplomatic pouch, and whatever it is, they can get whatever they want through customs. And if you can, and she, she was willing to do it, and it was a very dire situation, and she was willing to do it. And then someone on her staff drove out to wherever they lived, and they gave it to them. So if all else fails, but that is a very unusual.
You should think about the church. That's a great idea. Your viajeras, other means. And I'm pretty sure, somebody tell me if I'm right about this, I don't think the U.S. consulate in the country will help you at all with service process. They're prohibited, I'm pretty sure.
No, not at all.
So you might get, so the best way is kind of hook or crook. Honest crook, of course.
Mm-hmm.
So you can represent to the court properly. Because you do, at least in Philly, they always require original signatures. Like you can fax it down, but it's got to come back with an original somehow.
That's the other thing, these lawyers, I keep pitching global workers. I'm not, I don't have shares and stock or anything. It's just that they're so efficient, and it's so easy because you're dealing with a lawyer in another country who has basically the same mentality that you do. They know what you want. They know you need it right away. And I get the originals too. So.
I think we have what? We have no time left. So if you have any questions, email. Can I have those lists back, by the way, the sign-up sheet? What, did I forget? Oh, gosh, we didn't do any kids testifying. Wait.
Can you go left?
What do you want to do? Yeah, I mean, if you're not a regular family court practitioner, and you've never had to prep a child to testify, you need any family law practitioner knows about that. There's nothing distinct about this type of case. Having children testify. Yeah, I guess like we have the sign-up sheets back wherever they landed down there.
Okay. Children. One thing with the children, if they testify, prep them not to minimize what happened to them. That's a common.
And it's okay. Tell them it's okay to cry. Crying's good. You know, all those things.
The judges are nice because these are judges who are hearing these kinds of cases. So the judges are usually.
1 second, almost done.
Just the judges are sensitive to the fact that these are children and they've been through a lot. They've read your petitions and they know that these kids have had a really, really difficult life and they are not going to be in their face and giving them a hard time. Plus, you know, certain judges are assigned to handle custody. Certain judges are handle handle dependency, and other judges are handling criminal cases. They're not going to handle this case. They're usually not going to give the attorney a hard time, especially if they know that you're doing it pro bono, and they're certainly not going to give the child or the
well, and although that may not hold true. I don't know. Justin, you're getting a hard time in Lehigh County, right?
But that's the culture.
But are we still filming?
But unlike immigration court, right, the whole purpose is to work with children, right? And so I think even explaining to your clients that this is about they want what's best for you, they're not trying to deport you, is a huge distinction to make when walking into family court, because the child's perspective may be only knowing those removal proceedings if they have concurrent removal proceedings. And so it's just really articulating those differences of the two different courts and using very simple visuals, very simple language for children is critical. And I think, as we said, all of us are happy to talk in detail once you have
And
cases.
you see how many people just up here are doing these cases. Even though it sounds like a lot, I'm sure sitting there, a lot of you are overwhelmed thinking, oh my gosh, do I really want to get involved in this? It's really not as bad as it sounds. It's just once you have all of us as resources, we'll walk you through the whole thing. And once you get in there and you see it's really not that difficult. It's really not. It's just that it's not, if you're not used to doing that type of law, it seems a little overwhelming. But these are incredibly gratifying cases to take.
And they're great clients. They're great. I mean, we haven't talked about this, but they're
Kids
wonderful,
are amazing,
resilient clients that you will be so happy to stand up next to in court. And so all of the work is a lot less burdensome than it sounds because you're standing next to these great kids.
One thing, everybody here worked, just one sec, Jay, if you don't mind. Everybody here worked with an interpreter before? No? Okay, one word about interpreters. Don't use family members. Because the family members...
In court, you're not allowed.
No, I meant even in interviewing in your office, try very hard not to use a family member, just because their English may not be so great. I've seen attorneys, think one thing's being said to them, they write it down in the pleadings, you get to court, it's something completely different. Oh, no, they're not dead. Oh, whoops. Be very careful, I thought the same parents were dead, were they not? So if you haven't used an interpreter, you don't know how to, if you haven't had the opportunity to work with them, ask about that too. And don't just use any cousin they bring in. Judy, close us out.
This is a fantastic gold mine here of resources and shared information. And this is just the beginning. And I think it's right. Philadelphia is so great because what we have here is really unique, this cross-referencing the family law and the immigration law. And I'm nominating Catherine Miller-Wilson, who works at Highest, but used to be a master in family court. So she's a walking example of interdisciplinary work. And if you have any materials that you've used or pointers that could be helpful, please send it to Catherine, and she'll make sure everybody who signed up for the training gets it. and we need to create this listserv and share it with each other. And that way, we'll learn about Delaware and Montgomery and all these wonderful tidbits. And so anyway, Catherine, can you tell everybody your email just in case people don't know?
Yeah, I think I have everyone. Everyone here has gotten an email from me, yes?
Yes.
Any no's? Okay.
Okay, you got it.
I will be following up after the training, and absolutely, those of you that have done these cases that have extra things to add, send it to me, and I'll pass it on to the group.
And we may
Please
post
give me your service.
stuff on our website if
Yeah.
we have your permission. We may post things on our website.
Oh, I will. It's
I will.
it's-